Hello guys and welcome back to another video on the environmental law series, and today in this chapter we are going to learn about various principles with regards to the environmental law. As we know that in the last chapter we have already learned about various conventions and declarations, and our last video was about the Stockholm Declaration. So now let's move on to the various principles in relation to the environmental law. Now in today's chapter we are going to learn about the precautionary principle. Now what is precautionary principle? The word itself, the word precaution itself means to be safe or to prevent. Okay, now you can say that precautionary principle is one of the essential features or essential principle when it comes to the environmental law with regards to the sustainable development. The whole aim of the precautionary principle is to take precaution rather than to face the consequences. Therefore, in this principle, we learn that in case one sees that a certain act or a certain activity could cause environmental degradation, it is to be seen that such act is prevented rather than moved on with. Therefore, this precautionary principle is highly based on the foreseeability. Therefore, it is not necessary that one should look into the scientific proofs or scientific facts before taking the precaution. Okay, so it is quite obvious that in such a case, the main aim or the main objective is to look into the common sense as to such a act or such a activity can cause environmental degradation or not. Precautionary principle mostly is based on the prevention rather than cure. Therefore, if one company or one factory sees that one certain activity may or may not have such an adverse effect on the environment, it should be made sure that a long-term action is taken with regards to such activity. And this approach was adopted in the Rio Conference of 1982. Now, if you look into the history of the precautionary principle, we observe that in the earlier days, this principle was based on the assimilative capacity rule. Therefore, the earlier approach with regards to the precautionary principle was research first and then the precaution or the whatever action is need to be taken. So it was very necessary that the research was done before any action was taken. But now the stance has completely changed, as the research or any scientific proof is not necessary, as we know that it might take a lot of months or even years for these proofs or for these experiments to be conducted, and the environmental related issues are considered to be very sensitive in nature and they can be very time constrained. The precautionary principle was born due to inadequacy of science. Therefore, what happens is, as I just now told you all, that the science and the research usually takes a lot of time, and there are a lot of data which needs to be collected, there are a lot of samples which needs to be experimented on. Therefore, it might take a lot of time for such a research to move on. Okay, so environmental matters with regards to such a case can be very sensitive, as I just told you all. Therefore, it's better to foresee the problem or foresee the environmental degradation. Therefore, it is very necessary that no time is wasted on any kind of research or any kind of sampling. The first time this principle was acknowledged was in the Vienna Convention of 1985 for the protection of ozone layer. Furthermore, Montreal Protocol also speaks about the precautionary measures to control the global emission of the ozone depleting substances. Now let's move on to the applicability of the precautionary principle in India. Now, if we look into the various judgments which are given by the Supreme Court, we come to realize that Supreme Court is very fond of the precautionary and the polluter based principle, which is going to be our next video. The Supreme Court highly believes that the precautionary principle is one of the most essential principles of the environmental scenario in India and also the sustainable development, including the international customary laws. One of such landmark judgment with regards to the precautionary principle is the Vellore City Welfare Forum versus the Union of India. So what had happened in this case was, a petitioner filed a public interest litigation under Article 32. Now, what had happened in this case, if you look into the facts of this case, is that the petitioner had filed this case against the discharge of the untreated effluent by the tanneries. Okay, now these tanneries are nothing else but leather factory or leather industries. okay, in the state of Tamil Nadu. These tanneries would discharge the untreated effluent in the agricultural field, the roads, roadway, and also the river Palar, which is the source of the water supply for the residents. Moreover, the underground water also was affected, as well as the 35,000 acres of the agricultural land became partially or totally unfit for cultivation. Later on, the Supreme Court ordered the central government to form an authority, and moreover, not only the precautionary principle but the polluter pay principle was also applied, wherein the affected people were compensated. Moreover, Green Branch was also formed in Madras. I'll be dealing with such more cases and more judgments in another whole separate video where I'll be dealing with all the important cases with regards to the environmental law. So that's all for today's video. I'll see you around in the next video where we are going to learn about the polluter pay principle. Thank you so much. Bye.